All rise. Court of Appeal for the 6th District of the State of Florida is now in session. The Honorable Meredith L. Sasso, Chief Judge, presiding. All persons that are before the court, volunteers in attention to you will be heard. God in the United States of America, the State of Florida, and the Honorable Court. Please be seated.
All right. Good afternoon and welcome to the oral argument session of the 6th District Court of Appeal. We have two cases set on our afternoon docket. The first is 23-1145 Progressive versus Simon Med. Start by introducing the judges that we have with us today. We have Judge Dan Traver from Orange County and also Judge Josh Mize, also from Orange County. Please be aware that today our proceedings are being streamed live on YouTube where they will stay. So if everybody could be cognizant of that and also silence any cell phones that are in the room, I appreciate that. With that, we can get started. And I have 5 minutes up for rebuttal unless I hear otherwise.
Yes, please, 5 minutes. May it please the court. My name is Deanne McLemore and I represent the appellant Progressive Express Insurance Company in this matter. I'd like to say 5 minutes for rebuttal, please. The sole legal issue on appeal is whether Progressive paid the proper reimbursement amount under the PIP schedule of maximum charges when it paid pursuant to the 2007 participating physicians fee schedule. We believe, based on the unambiguous plain text of section 5A1 and 5A2, when read together consistently as a whole, the answer is clearly that Progressive paid the right amount under using the 2007 participating schedule. Now, as extensive as we talked about extensively in our briefs, there is a 3rd district opinion, Priority Medical Centers versus Allstate, that is adverse to our position. I'll bet that case arose in a different context, arose in a benefits exhaust context of an overpayment. This is more of your standard PIP case of an underpayment. There was a 4th district Court of Appeal opinion, Allstate v. Castle, that was adverse, but just a few days ago, the 4th district issued a unanimous en banc decision receding from its Castle opinion. Progressive was the party in that case. I provided that to this court through a notice of supplemental authority. We presented the same arguments in the 4th district as we presented to this court in our briefs, and we're going to present here today. Based on those arguments, the 4th district agreed that Progressive paid properly pursuant to the 2007 participating rate, that the 3rd district's opinion was legally wrong, and it actually certified conflict with it. In this oral argument, I'd like to discuss 3 points. First, we believe that based on the text of the PIP statute, the unambiguous text that section 5A1 and 5A2 when read together, it's clear the proper reimbursement rate is the participating physician's fee schedule. This is the only fee schedule at issue that's expressly articulated by the Florida legislator in section 5A1. Now, section 5A1, as we discussed in the briefs, encompasses the schedule of maximum charges. This is where the Florida legislator listed 6 different PIP schedules that an insurer can elect to reimburse a provider under. Not all of these schedules are based on federal Medicare law. Only 4 of the 6 are based on different parts of Medicare, subpart F. The particular provision we're under undisputedly is based on Medicare Part B. It is the only PIP schedule based on Medicare Part B. We are under subpart F1, which is the legislator tied the payment formula to the allowable amount of the participating physician's fee schedule. Now, subsection 5A2, the one right below it, and the provision that is in dispute here, that section is actually a modifier paragraph that provides greater specificity to 5A1. We know this because the provision actually says that. The first part is for the purposes of subparagraph 1. And what the legislator did here is it provided guidance to how you come up with the base rate for the fee schedule that you were given, that is at issue in 5A1. It provides the service year, how you calculate that service year, and then the legislator wants us to compare that to the 2007 rate of that same fee schedule to provide an apples to apples comparison and pay the higher amount. And that's what 5A2 talks about. It relates back to 1, and it's an apples to apples comparison. And that is exactly what Progressive did here correctly. Now, Simon Med claims that Progressive should have paid pursuant to the 2007 limiting charge, despite the limiting charge not being mentioned at any point in time in the PIP statute, the entirety of the PIP statute, or at any point in which the schedule has been involved with the PIP statute for 22 years. Simon Med's argument is entirely founded upon the 2012 amendments to the PIP statute of 5A2, where the legislator removed the words participating physician and replaced them with applicable schedule. However, to get to Simon Med's result that this means the limiting charge, you have to read 5A2 in complete isolation with the rest of the schedule. You have to read the statutory amendments of 2012 to 5A2 in complete isolation with the rest of the amendments that took place in 2012. And then on top of that, you have to ignore what the limiting charge actually is in the federal Medicare system. If we're looking at the statutory history, that is the basis of the argument. In 2012, the Florida legislator did a substantial amendment to the PIP statute. It was a broad-ranging overhaul of the entire statute. The provision at issue here, 5A1F, was amended in 2012. It is an amendment that Simon Med doesn't even tell this court about. What the legislator did here is it expressly added 2 more Medicare Part B fee schedules: the ambulatory clinical laboratories in F1 and the durable medical equipment fee schedule, which we call the DME fee schedule, in F3. These new schedules did not exist in the PIP statute before 2012. Only the participating physician schedule existed in the PIP statute before 2012. Therefore, when the legislator added these 2 new fee schedules, now subpart F encompasses 3 Medicare Part B fee schedules. It had to logically amend subsection 5A2 to encompass them all. These sections relate to each other. So now, instead of just saying that it relates to the participating physician's fee schedule, the 2007 minimum statutory language for the fee schedule, it says, except it may not be less than the applicable schedule of Medicare Part B. That applicable schedule is the schedule chosen by the Florida legislator in the section right above that subsection 5A2 modifies. They did not change this language to open the floodgates for a provider to claim higher amounts based on a Medicare function that the legislator didn't put in the statute. Subsection 2 relates to subsection 1. The amendments logically relate to each other. The broadening of 5A2's language relates to the broadening of the number of fee schedules added to 5A1. You know, in 2012, when the legislator added these new fee schedules, these Medicare Part B fee schedules, it didn't add the limiting charge. And it makes sense why it didn't add the limiting charge, which leads me to my next point. The limiting charge, despite what the 3rd district held and what Simon Med argues here today, is not a Medicare Part B fee schedule. It's not even an amount that Medicare pays. What it is a surcharge that Medicare allows a non-participating provider in Medicare that does not accept an assignment to charge directly to the beneficiary, the Medicare patient, the Medicare insured. So really the math works out that the non-participating provider charges 115% of the non-participating physician's fee schedule, which is 95% of the participating. That 15% above the schedule is what we call the limiting charge. It is a balanced billing measure that the federal government allows these non-providers to do, but they cap it at 15%. So functionally, it's the equivalent to your out-of-network providers under your own private health insurance.
So what do you say to the argument that because the statute includes the phrase, the schedule of maximum charges, that because this limiting charge would be technically the maximum that could be charged, that it's somehow incorporated into the statute?
Yes, Your Honor. The maximum charge to whom? So the limiting charge is the maximum charge to the patient, not to Medicare. The maximum charge that Medicare pays under the non-participating fee schedule, because that would be the fee schedule the limiting charge applies to, would be 95% of the participating charge. Progressive paid the participating physician's fee schedule, which is actually 5% more. And of course, PIP is 200% of that. So if Simon Med submitted its bill to Medicare as a and if Simon had even proved that it was a non-participating provider that then didn't accept that Medicare assignment, it would receive less money for Medicare than Progressive paid here. So actually, the participating fee schedule amount is the maximum amount, the highest charge that Medicare would have paid. The only way to get to the fact that the limiting charge is the highest charge is by ignoring what that means, because it would then put that financial responsibility onto the insured patient, which we're not allowed to do in PIP. The Florida legislature specifically requires PIP be an 80-20 split between PIP carriers and the insureds, 20% representing the insured's copay. Infusing this limiting charge, how it's supposed to be done in Medicare, would make that incompatible with the 80-20 split, because on top of the 80% that Progressive would be required to pay, 80% of the non-participating physician's fee schedule amount, the insured would have to pay the 20% copay plus the 15% that is not allowed by the Florida legislature under PIP. It's simply incompatible. You cannot take the total amount like Simon Med is arguing, because you would have to ignore what that total amount encompasses. And that total amount leads to my third point, which is this whole notion that Simon Med is here under an assignment of benefits. But the only party to this appeal that is trying to get the insured the most medical coverage is the insurance company, Progressive. Simon Med took an assignment of benefits, which means it's stepping into these shoes of our insured, Ms. Brown, in this matter, but yet they are arguing a position that's adverse to this insured, that is to the detriment of this insured. Why? Because paying them the limiting charge just to simply pay the medical provider more when the statute doesn't tell us to, means that the insured's co-payment amount would be higher. So her out-of-pocket expenses are now higher, and her policy would exhaust faster. As we know, PIP, there's a finite amount of benefits.
So let me ask, speaking of exhaustion and benefits, assuming if this court took your position, do you see any way to reconcile that with the third district's opinion and priority medical because of the nature of the case and how that arose? Or do you think we would have to certify conflict?
So the third districts, as Your Honor pointed out, the factual context in which the third district's opinion came out was an exhaustion of benefit context, which is different. The result of those cases can stay the same under a Ben-X analysis. However, the third district's legal analysis is wrong. The third district took the opinion as took the case as a certified question of law, and it answered the legal question. Therefore, while the facts are distinguishable, the legal reasoning is absolutely wrong. As the fourth district did, they believe that legal reasoning was wrong, and they had to certify conflict.
So no way to distinguish in your view. In terms of whether a certified conflict.
I believe that you would have to do the third district's case, the holding particular to the facts of the case, but the court would still have to conflict with the legal reasoning, which is absolutely wrong. Before my time runs out, I would like to mention one final thing, is that late Thursday, Applee filed a notice of supplemental authority. I'd like to address that real quick. The alleged authorities provided didn't come from the record on appeal, didn't come from anything in the trial court, didn't come from anything in the briefings. There's no legal or public citation to this information. It feels like
They were certainly available at the time of briefing as well, correct?
Yes, in Applee's brief, they make no argument about MPPR and the ambulatory, the clinical laboratories, the DME fee schedule. They don't mention that, despite us mentioning them briefly in our cases, in our briefs. This is not an MPPR case. What appears to be the schedule amounts for 2012, like the actual physical base amounts that Medicare pays, I believe that's what those are. They're not at issue here because those aren't the schedules we're under. We're under the participating physicians. Because there's no arguments, oral argument, you can't make new, as the law requires, you can't make new arguments at oral argument. You have to stay within your briefing. So we'd ask the court to disregard those materials as improper. And unless the court has any more questions, I'd like to reserve the rest of my time for rebuttal.
Thank you.
Good afternoon, your honors.
Okay,
May it please the court, counsel. My name is Clay Schott from the law firm of Hogan and Hogan. This is Jeremy Hogan. And we are here representing Simon Med Imaging in this case. And as I assume you could, or I'm assuming you probably know, we are taking the position that the third DCA is correct in their opinion. And it doesn't matter that it's an exhaustion case versus an underpayment case. The legal analysis is the same. And I go through it in my brief. But before I get to that, I want to just make it clear that I mentioned at the end of my brief. There's no indication in the legislative history, no evidence that the legislature did a deep dive into the Medicare statute or the Medicare website to find what limiting charge is. It's more likely that they looked at the physician's lookup tool, which is page 3 of my of Appellee's amended appendix. And you see when you look at it, there's four schedules of charges there. 2 of them are exactly the same and 2 of them are exactly the same. The non-facility price and the facility price are the for the physician's fee schedule are the same as the limiting charge, non-facility price, and the limiting charge facility fee schedule there. So there's really 2 schedules there that you're looking at. But the point is that it doesn't matter what Medicare defines as the limiting charge. The legislature didn't adopt all of Medicare's policies and procedures. They didn't adopt the entire statute. It matters what the legislature thinks the limiting charge is. And we can see that from the history of the statute.
can we start though? I understand your argument on statutory history. Can you make the argument without referring to the prior versions of the statute based on the plain language of the text of the current statute?
I'm
Or
sorry.
do you? So I understand your argument to be when you look at the prior versions of the statute, this language was different. We have to assume that by amending the statute, they meant something different. But can you make the same argument that the limiting charge should be the charge that should be the amount that Progressive reimbursed at in this case, without referring to prior versions of the statute and based only on the language of the current statute?
The exception, as I call it, the word except is very important in this case. And they kind of ignore it, to be honest with you. And when you see the word except, it says, the beginning says, I get ice cream on Sunday, except if I'm not a good person. Okay, so it completely changes what's in front of the word except. And so here where it says, except the applicable fee schedule, it opens the door up to all of the available fee schedules that the legislature would have seen when they looked at that physician lookup tool. They would have seen the limiting charge and they would have seen the non-facility fee schedule. And the exception opens the door to all of that because it says applicable, which is a broad band. And there was no reason to remove those words, participating physicians, in order to accommodate the DME schedule or the ASC schedule or the lab schedule, because they don't, the limiting charge doesn't apply to them. And they say that in their brief. The limiting charge does not apply to those schedules. Those schedules simply have one payment if you're depending on the state you're in. So they didn't need to broaden the language of 5A2 in order to encompass these 2 additional fee schedules that they added, because the language didn't affect those 2 schedules at all. Those schedules are what they are, and there is no ambiguity in them, and there is no choice to be made when you look at the schedule to decide what is the charge for this particular service, CPT code, supply.
They're referred to though as fee schedules, right? I mean, the durable medical equipment and supplies fee schedule.
Correct, but they do not have a limiting charge, and the limiting charge doesn't apply, and appellant has told us that.
Okay, so your argument is that based on the plain language of the statute, the fact that there's an except that modifies the term applicable fee schedule, because it refers to the word applicable schedule, that it could be anything that could be paid under Medicare rather than the explicitly delineated fee schedules.
That is
you're
my
above that
position
language.
in relation, but my real position is what's in my brief, that the legislative history matters, that the
Okay.
change matters, that the addition of those words. were
So
meant-
how does that work in operation of law? Because it would seem to me strange that in order to understand how the statute works, somebody would first have to read. I mean, just a layperson would first have to find 5 prior versions of a statute in order to understand what a statute means.
Well, I don't think the layperson, with all due respect, is digging through the statute and trying to figure out what needs to be paid and what doesn't need to be paid in PIP. This is a very limited area of law.
But
And
patients or anyone else looking through it are entitled to look at it.
they are, absolutely, and their assistants or their billing people look at the physician's lookup schedule all the time to see what it is that they should be charging, or oftentimes they will.
But you're saying those assistants should also go back and look at the prior versions of the statute, make some legal determination what the meaning of the change is.
No, that's not what I'm saying. I'm saying that the law says that we look at those things when we change a statute. We add words or we remove words. This is a legal argument about what we as lawyers do. I'm not saying that the doctors have this responsibility to dig back through or whatever.
Are you saying to deduce the meaning of the current language of the statute? That's what somebody would have to do, doctor or lawyer or someone else. You're asking us to do it, but if they were reading the statute themselves, you're saying anyone reading the statute would have to go back to those prior versions to deduce the meaning of the current statute.
Except that medical providers are well aware of what's happening in the world, those who accept PIP, because not every medical provider accepts PIP. Lots of them do not accept PIP. They treat patients under letters of protection because PIP doesn't pay enough to cover all of their expenses and their overhead and everything else. So those that accept PIP are well aware of what the current situation in PIP is and what fee schedule they should use and shouldn't use. That's just something that is commonplace in the medical industry for PIP billing medical providers, but there's a significant amount of providers that don't bill.
How do we measure the level of their awareness of the legislative history?
Well, I guess you'd have to ask them.
Okay, so that's something we can't do.
Not here today, we cannot.
Okay, so that's.
What's your response to the argument that in subparagraph 2, that it explicitly says, for the purposes of subparagraph 1, the applicable fee schedule is, and then modifies that applicable fee schedule with the floor of the payment essentially.
Are we talking about,
are we-
are we talking about 2011 and 2012?
The current one, is it 2012?
Okay.
So subparagraph 2, for purposes of subparagraph 1, to me, that signals, certainly could signal, and this is what your friend on the other side is arguing, that by referencing subparagraph 1, it is explaining in very clear terms that the purpose of this paragraph is to provide more specificity for those fee schedules, and they are referred as multiple fee schedules, the participating fee schedule, the durable medical equipment fee schedule, that it's meant to modify those multiple schedules that are listed in paragraph 1 as subparagraph 2 says.
So the first section of paragraph 2, where it says for purposes of paragraph 1
Mhm.
or subparagraph 1, they're talking about the applicable fee schedule for the year in which the date of service occurs. And they're declaring it's March 1st to February 28th or February 29th, depending upon the year. That's what that sentence is about. It's telling the medical provider and the insurance companies that you use the schedule from March 1st to the 28th or so of February. That's all that first sentence is telling them. Then it says, and it does say notwithstanding any subsequent change, because as you all know, there's been multiple times where the PIP schedule, where the PIP fee schedule has changed. There's a 2015A and a 2015B schedule, for example. Because there was a change in the consumer price index or something that caused the fee schedule to go up. So that's what they're talking about in that first sentence. But then they have that very last sentence where they say, except that it cannot be less than the allowable amount under applicable schedule of Medicare Part B for 2007.
So is it your position that the applicable fee schedule phrase that follows the purposes of subparagraph 1 has a different meaning than the same phrase applicable schedule that follows in the second sentence?
I'm saying the word except creates that different meaning.
But is the answer yes, that the applicable schedule would have 2 different meanings in the same paragraph under your argument?
It does, and they had the legislature not removed the words participating physician, they wouldn't have 2 different meanings. But they do because the legislature took those words out and they meant to make a change. And we know what that change was.
And
They
so what's your argument that the change was that now there are 3 potential fee schedules in subparagraph 1, whereas before there was only the participating fee schedule?
There's still only 2. The limiting charge is always higher than the non-facility fee, always. And they only looked at the limiting charge in 2007 as the floor of what could be paid. They reference in their brief how they created this floor of 2007 in case the price goes down over time. And the price has gone down over time for certain services. So a lot of 2007 is used, not all of it. There are multiple diagnostic studies that currently pay more today in the year 2022 than they pay in 2007 under the limiting charge. More today under the non-facility charge or price than under the limiting charge. So it's not all of the charges but there's only 2 schedules. The limiting charge is always higher than the non-facility fee. So you don't even have to look at the non-facility fee in 2007. In 2022, if we're talking about this year, you're looking at only the non-facility charge. You're not looking at the limiting charge. So there's only 2.
You answer my question.
All right, so let me just add a couple of things, all right? And I don't know how much time I have because I don't know when I started, so I apologize.
You have a little over 8 minutes remaining.
Okay, all right. I mentioned there was no need to broaden the language. We talked about that. And the other thing that is in my brief that I talked about is the fact that they only removed those words from the exception. They didn't remove them from any other place in the statute. And if they had not intended to change the meaning of the statute, there was no reason to remove them, or they should have removed them all if they wanted to make it all consistent. Once they made that determination back in 2003 that they had to amend the statute to add those words in order to, quell the litigation that was taking place on the issue of whether the limiting charge was in or out, they made it clear it was out, and we went 9 years with it out. But then they removed those words, and that creates a change in the statute. And as the case law clearly says, the legislature doesn't remove words unless they have an intention to change the statute. And there was no need to remove the words because it didn't affect these other 2 DME schedules or the other 2 fee schedules, the DME and the ASC schedules, because the limiting charge doesn't apply to them at all. So there was absolutely no need to make that change. That's really basically it. I mean, that's what the 3rd District Court of Appeals said. I think they're correct in their argument. I don't believe it matters one bit whether benefits are exhausted and you're talking about whether a gratuitous payment was made versus benefits are underpaid and they still need to be paid. I don't think it matters one bit. There's a change in the statute. The words have been removed and the legislature had an intention behind that. And the question is, what is that intention? And the final bill analysis and the committee notes all say that they wanted to broaden the schedule. And they also added, they wanted to broaden the schedule of maximum charges. And they wanted to add these, a couple of methodologies. She mentioned MPPR is one of them. And they mentioned in their brief that use of those methodologies will cut the amount of money that the insurance company has to pay and the amount of money that the patient has to pay. And if you're cutting those amounts, there's no reason why, that explains why they would want the limiting charge in play, because if the floor is going to get cut down with the 2nd, 3rd, and 4th procedure, then the floor should be a little bit higher to accommodate that, because the Medicare providers aren't going to be, or the medical providers aren't going to be getting paid as much as they were once they add these new methodologies in that they talk about in their brief. So that makes the perfect sense as to why they would increase or why they would want the limiting charge back in play. And there's no dispute that after 2015, a number of the charges, a number of the payments to the medical providers did go down because of these other methodologies that were added. So I don't think there's any evidence that they went up. I think it's clear that they went down. And that's what I've seen in the 27 years or so that I've been doing both PIP and bodily injury, because my practice is both 50% personal injury, bodily injury, and about 50% PIP. Any further questions?
Any other questions? Thank you.
Thank you.
So Simon Med's entire argument about the legislative history, I just want to point out the legislative history actually never mentions the limiting charge since 2001. You have legislative history, which should actually be one of the last prongs that you look at in doing a textualist analysis. But at no point,
Last prong or not a prong?
if you're under the kind of Scalian version, I would say probably not a prong at all, because not all the legislators sign on to legislative history, and as the staff analysis that they included in the appendix says, doesn't represent the opinions of the House of Representatives. Under a proper textualist approach, you look at the statute and what the statute said. You should not have to go to 22 years of legislative history to figure out what the legislative clearly meant in the text that it put in the statute. The legislator never said it looked at the CMS search tool to figure out what are the schedules for PIP. This is all just stuff that has no support for this legislative history. Going to the actual text of the statute, when he says this exception, it says that you have to compare, except that it cannot be lower than the allowable amount under the applicable schedule for 2007. It does not say the limiting charge of 2007. The reason the legislator broadened that language to applicable schedule is because the other two schedules do apply to the comparison. Contrary to what they even argued in their briefs, they argued for a comparison of the service year participating amount, the 2007 participating amount, and the 2007 limiting charge amount. They're asking for a three different allowable amount comparison. Today, they're arguing that no, the 2007 only means the limiting charge. It doesn't say that. It says the applicable schedule.
Could
Which-
the insurer reimburse at the rate of the limiting charge if it wanted to?
The insurer.
Yes, the
Oh.
insurer, yeah,
I would
insurance
argue-
company.
Sorry. I would say that if you no, and the reason is because it is not a schedule that has been articulated, a PIP schedule of maximum charges is not a schedule that's been articulated by the legislator. Potentially, if you're looking at subsection 583, where in 2012, another amendment was that the legislator allowed insurers to look at payment methodologies and coding policies of the CMS, Centers of Medicaid, Medicare Services. However, payment methodologies and coding policies are terms of art. They're not just, they have meaning. And those meanings, there are lists of these payment methodology and coding policies that actually serve as a price adjustment to the fee schedule amount for some economic justification. That is an amount Medicare would pay, but it's a downward price from your base rate that you've established in 5A2. Progressive's position would be that if you wanted to consider limiting charge as a payment methodology, even though that's not what Medicare, this is just assuming for argument's sake that that's not what Medicare defines it as, then Progressive then would be taking a price, would be paying less money, but then its insured would be paying more money. And because of that impact on its insured, it wouldn't do that. It wouldn't choose to do that, even though, again, it doesn't fit the terminology, payment methodology. It's not what it is. And Medicare tells us that. Also looking at 5A2, Judge Sasso, I know you talked about how 5A2 is, the sentence we're talking about is one sentence that talks about the applicable schedule, those terms, multiple times in the schedule, or multiple times in that one sentence. They are prescribing different meanings to the terms as the sentence flows on from the beginning to the end and saying it's some kind of exception. The legislator never said to prescribe different meanings. And I also want to point out too, so they're reading 5A2's first sentence, the second clause in total isolation from the rest of the sentence and total isolation from 5A2 as a whole, but they are also not giving due regard to grammar. The exception said the allowable amount under the applicable schedule. That's a definite article that requires us to say there's one singular, it means one particular thing. They are trying to have this court read in an indefinite article of "and" or an allowable amount that is a general article. The legislator didn't put that in there. The legislator didn't say allow an allowable amount under an applicable fee schedule or the highest allowable amount under an applicable fee schedule. It said the allowable amount under the applicable schedule. And because the modifier paragraph, we have to look at the section it modifies, which is section 5A1. And I just want to address one last thing. I know my time is running out. Simon Med makes the argument that the limiting charge used to be applicable in the PIP statute. And then through the 2003 amendments, the legislator said, no, we're going to ignore the limiting charge fee schedule for the participating. And that now the 2012 reopened the door. The door has never been open for 22 years of the PIP statute schedule when it's put in by adoption, Medicare fee schedule. The limiting charge has never applied. The legislator has made it clear, if you want to look at the statutory history, the legislator has never allowed the limiting charge. It's never said the limiting charge in any of its legislative history, its amendments, ever. So we cannot just assume that's what they felt, was that the limiting charge was a fee schedule not applicable. They never said that. The door's never been reopened. And through an isolated reading of 5A2, Simon Med and medical providers are trying to rejuvenate a dead issue that has always been dead to the legislator for 22 years. 10 seconds. If the court has any questions, I'd love to answer them. Okay, thank you.
Thank
so
you very much. All right.
Oh, Your Honor, I'm sorry, 5 seconds. We'd ask this court to reverse the judgment on appeal.
We wouldn't have known otherwise.
Okay.
Yes,
Yeah.
last part of my brief. Thank you.
All right. Thank you both very much for your argument. All right, the next case on our docket is 23-1144 Hernando Lancheros versus Brian Burke.
Good afternoon,
Good afternoon.
and Klein here for the appellant, and I'd like to reserve 5 minutes for rebuttal.
Okay,
Our primary issue on appeal, trial court erred in this case in granting a directed verdict on causation. As the court well knows, directed verdicts on causation are very, very rare, and in fact, I couldn't find one that was upheld on a. They should only be granted where there's no view of the evidence whatsoever, or any inferences therefrom that could possibly support a verdict for the non-moving party. And the evidence must be evaluated in a light most favorable to the non-moving party, with every reasonable inference indulged in the non-moving party's favor. And of course, it is entirely inappropriate where there is conflicting evidence on causation. In this case, the trial court erred in focusing exclusively on medical evidence and to the exclusion of other lay evidence in the record. And let me start out by saying we believe that contrary to the plaintiff's argument here, there was in fact conflicting medical evidence as well as conflicting lay evidence. In this case, the lay evidence in question was totally undisputed. The plaintiff in this case had back problems before this accident. He was treated with a chiropractor, and he chose not to follow the entire course of the treatment. He didn't seek any treatment from anyone for 2 weeks after the motor vehicle accident. After which he engaged in some chiropractic care, but then didn't treat for 13 months. And the next treatment he sought was with a life care plan. The expert testimony in this case was that there was in fact a question as to whether or not there was any injury caused in this accident. Opposing counsel argues that we did not have any expert evidence to the contrary, but in fact, there were 3 radiologists who testified. In this
Did any of them
case.
speak to the muscle soreness that Mr. Burke said he experienced after the crash?
The radiologist, their radiologist, I believe, the first one said there was some bright signal, which tends
But
to.
the MRI, so the accident was in April and the MRI was in May.
Correct.
So in terms of my focused question about, is there anybody other than Dr. Tall that basically opined about what he was feeling in those 18 days in the accident's immediate aftermath before he went to go see the chiropractor?
No.
Right, so I think that's right. So I don't necessarily know that if I understand the trial court's rationale for entering a directed verdict correctly, which is the soreness, that any of those experts that you're talking about, presumably Foley, and the first doctor whose name I can't pronounce as well, Schwartz. Anyway, I don't necessarily know that those are on point, but please correct me if I'm wrong.
No, you're correct. Obviously, a radiologist is looking at a scan, not talking to the patient, and there were no records of any complaints to the hospital. As a matter of fact, he went to the hospital the day of the accident, and
So now
apparently,
we're in that abbreviated window. again.
correct.
So we're in that abbreviated window between accident and go see chiropractor. So an MRI that happened the following month after that wouldn't have anything to do with our decision. today.
That's correct.
Okay.
That's correct. But I think it is extremely important, something that the trial judge overlooked was the fact that at the hospital, the only scan he got was for his brain, and there didn't appear to be any complaints of back pain at the hospital. And Your Honor's correct, the first time there's complaints of back pain is some 2 weeks later.
And to further that point, then I guess the only thing that's going to get this case reversed for you is Mr. Burke's own testimony. Because Dr. Tall doesn't help you out in that regard, and the other 2 experts that you called can speak to that.
Actually, Dr. Tall did help us out in that regard. He specifically testified. And this is in our, it's in our initial brief and on our answer brief. He was asked about causation. So to be crystal clear about it, if this were the situation to where he subjectively had presented, told me he had pain in certain areas of his back and legs, and then when I did a neurological exam, he had those neurological findings, and then when I looked at the MRI, as I hope I've made clear, he had pressure mechanically on the nerves that correlated with those neurological findings. Then my opinion would have been that, yes, there's some causation here in reference to that incident, but that's not the case. And Dr. Foley said something very similar as well, that he saw no evidence of any even soft tissue injury, no causation whatsoever. And of course.
Well, here's the section that Dr. Tall, and it's obviously from their brief and yours as well. We see here that you say that Mr. Burke was hurt, but it just wasn't for this permanent serious damage disc. It was just kind of a sore back or sprain strain sort of thing, correct? The answer is correct. And you say that because it's a strain or a sprain, 6 to 8 weeks chiropractic treatment is all right, and it's reasonable, related, and necessary to the crash. I think that would be appropriate. Yes, sir.
He said it
So
was.
that's where it's fair to say that that's what the trial court seized on in granting the motion, correct?
That's correct. And as I read Dr. Tall's testimony, and remember, Dr. Tall's a CME who can only see the plaintiff years later and can only base his opinions on causation based on the medical records before it. And like I just read his testimony, he specifically said, I don't have anything that shows me that right after the accident, he was complaining about back pain. But what he did say was, and I think it's reasonable, look, if he had a sprain or a strain, at most he would have a sprain or a strain. And if he did, I think it's reasonable for anybody to go to a chiropractor, for 6 to 8 weeks or whatever it was that he said. But he could not, based on the records before him, say this man suffered a strain or a sprain in this accident, because the first time he even saw a doctor was 2 weeks later. So all he had before him was some testimony from the plaintiff. Yeah, I hurt my back.
We had a
and,
description of the accident, right?
Well, yes, I don't think there was much of a description of the accident.
Okay, but
Actually,
he'd
he
been a-
said he
he'd been an
vaguely,
esteemed orthopedic surgeon in town for 145 years. Maybe he'd seen his share of car accidents. Couldn't he draw from his background and experience and say, yeah, car accidents, if I look at that, yeah, that'll make you sore.
well, except that the plaintiff, I think, testified that he vaguely felt a tap. That was his testimony as to the car accident. So there was clearly a great deal of evidence, at least bringing the question of causation to the jury as a question of that. You cannot ignore, and the case law is very clear, the fact that he didn't complain of back pain at the ER and then takes 2 weeks to go see any kind of doctor. And actually after that, I think it's a couple weeks later, he sees his primary care physician and doesn't mention anything about the car accident, about back pain or anything.
So that's all evidence outside of expert testimony. I think what Judge Trevor is getting at is, Dr. Tall seemed to concede that, as to some soreness after the accident, he thought there was causation and no other expert contested that. So as to that little piece, some soreness, back pain after the accident, the expert testimony was uncontroverted, and the trial judge says the jury is not free to ignore uncontroverted expert testimony. And it may have been correct that as to that little piece, there was uncontroverted expert testimony. I think I took the crux of your brief, not that to be the main point. Yes, there was lots of contested expert testimony in that small piece, but that there was non-expert things that contested it. And that the trial judge's legal conclusion that the jury cannot contradict or reject uncontroverted expert testimony is wrong. And that when there is uncontroverted expert testimony, the jury can nonetheless say, I don't think the expert's credible. I looked him in the eyes. I thought he was a liar. I don't think he was very smart. I saw a picture of the guy and I just don't agree with the expert. It seems to me the crux of your argument is that the legal conclusion that a jury is not free to reject uncontroverted expert testimony is wrong. And that if there is other evidence, even if it's not expert testimony, as long as there's other evidence, the jury in fact can reject it and go with the other evidence.
That's absolutely correct. That was the emphasis in our brief, Judge. But I did want to also make the point that, arguably there was a contradiction in the expert
Yeah,
testimony.
Judge Mize had it right. It wasn't a hostile question. I think you took it as a hostile question. I think that maybe you should focus a little bit on the lay testimony as to what we have in front of us. And you touched on that a little bit.
Right.
But I
right.
think once the only person who opines as to post-accident soreness is your expert, and he says that it's related to the crash, that's maybe not your best place to go.
I understand, Judge. But there is clearly significant lay evidence that called some of the expert testimony into question and gave the jury a reasonable basis for rejecting even arguably undisputed expert testimony. Again, he didn't go to the ER right after the accident complaining of the back pain. He didn't go see a doctor for 2 weeks. He didn't complain to his primary care physician that he had any back pain at all. 2 of his experts, including his primary expert, Dr. Bondari, testified that they had LOPs, which is one of the things that the jury could consider as evidence of a bias. And the fact that the expert opinions in this case were based primarily on plaintiff's subjective pain complaints. And also, Dr. Bhandari was seriously impeached in his testimony. He didn't review prior medical records of the plaintiff. He didn't know his pre-motor vehicle accident history. He didn't know that the plaintiff didn't go to the emergency room unconscious He thought he went and got scans of his back, which he didn't do. So Dr. Bandari's testimony, expert testimony, was based on an incomplete and inaccurate medical history as he understood it. And as I said, that Dr. Bandari was their primary witness with respect to both causation as well as permanency. The radiologists on which they relied ultimately in both cases with Dr. Knapp and Dr. Mahan ultimately declined to give a definitive opinion on causation. And I believe Dr. Mahan said, I don't do that. I'm a radiologist and I don't have the information that a treating physician has. So it's clear from this record that there was more than enough expert and lay testimony to give rise to a legitimate question of fact. Judge Mize, you're absolutely correct that it appeared from the judge's question that he was under the misimpression that unless there is definitively contradicting expert testimony, a directed verdict is in order. He based his ruling on the Wald versus Granger case, which is not a case on causation, it's a case on permanency. And we submit his legal basis alone gives rise to a reversal in this case. In the event that this court is not convinced on the directed verdict issue, which would frankly render the other two issues we've raised moot, the trial court also abused its discretion in failing to instruct the jury properly after the directed verdict. The judge actually read the jury, the standard jury instructions on causation, even instructing them that they could find in favor of the defense on causation. And then when it was brought to his attention that in light of the directed verdict, those instructions were not appropriate, he then clarified to the jury, well, I've already found causation, so really only.
What do you make of trial counsel's statements that quote, I can live with that, close quote?
He specifically said he could live with that only after the judge rejected the arguments against that the jury was not being instructed properly. So the judge had already rejected the arguments that we had made after the directed verdict when the plaintiff's counsel said, no, we don't really need to change the jury instructions. That's when defense counsel got up and said, well, that doesn't make any sense. You've already granted a directed verdict. Then the trial judge says, well, they could, still find that some injury wasn't related, etc. And it was only after the judge had
That's absolutely
rejected.
correct, isn't it? Because the only portion of the directed verdict finding was as it relates to the soreness and the ensuing chiropractic care. So that's absolutely correct. Like that jury could have returned a 4-figure verdict just for the chiropractic treatment, found no permanency, right?
Well, and that's true, except for the fact that then he instructed them that they could find no causation. He totally instructed them to the contrary. And it was only later, after the jury had been fully instructed, that he said, well, wait a second, I told you that you could find a verdict in favor of the defense on causation. What I really meant to say is that you could.
Well, I think what you might be trying to argue is that maybe the trial judge should have been more specific in his preemptive instruction that was delivered. If we don't agree with you on your first point correctly, after he gave the causation instruction, which would have completely unwound the directed verdict that he just entered. I think the argument that you might be trying to make is that preemptive instruction that was given later wasn't specific or good enough. And then that brings me back to full circle. What happens if you say, oh, I can live with that? That's
No, I actually didn't have a problem with the preemptive jury instruction, except for the fact that it then conflicted with the 4 or 5 other causation instructions that he had just given the jury.
right. The
Now,
causation instruction that he just given the jury was as if the directed verdict motion was never granted,
Which is-
I definitely have no problem with.
Yeah, which is
Fair.
why we actually re-argued our directed verdict motion. We said to the judge, well, now that you've done that, can you reconsider? The judge obviously didn't.
If you had been there as appellate counsel advising the trial counsel, would you have told him to say, I can live with that, or would you have told him to say, I renew my objection, Your Honor?
I would tell him to say I renew my objection.
And you have a little under 3 minutes remaining if you'd like to
Okay.
reserve it for rebuttal.
The only other point we raised was with respect to the admission into evidence regarding Dr. Raff's summary of his numbers for future medical care. I think we did in fact object properly. The judge was absolutely wrong in providing it to the jury. And in the event that this court reverses for a new trial, we would respectfully request that the court also instruct the jury that summary was inappropriately admitted into evidence. Thank you.
Thank you.
Good afternoon.
Good afternoon.
My name is Brian Lee. I am representing Ryan Burke in this appeal as the appellee. Start off with a directed verdict. The trial court, and I actually looked at my brief. I want to make sure I got it right.
Just before we get there.
Yes.
Yeah, just because I just want to make sure you take no issue with what your colleague said about the standard. This isn't a very friendly appellate standard for your position. Would you agree?
I do. And I also agree, I think, with what Ms. Klein said was that, and this was sort of baffling to me, is when you start looking in Westlaw or wherever we look for directed verdict and causation, there's a lot more on permanency than causation. And I think part of the reason that is because of the fact that once you get to permanency, you've kind of already gone past causation. You know, there's already an injury that's there. And the jury's deciding whether it's permanent. But I did want to mention some of the cases that we did cite, because I think that the standard when we're looking at a causation is a little different than what was told. I'm citing just a couple from Ryan versus Atlantic. It says that when the manifest weight, probative force of the evidence clearly requires verdict for one party, and evidence is legally insufficient to support a verdict for opposing party on the issue, it is the trial court's duty to direct a verdict. And the Allstate versus Thomas kind of piggybacks on that and says when evidentiary conflicts between testimony of experts and lay witnesses are what they call minor or indirect, they will not overturn a directed verdict. Now, Allstate was talking about permanency, but we feel that the permanency cases present a roadmap for
Counsel,
causation as well.
do you dispute that a jury can listen to an expert and say, I think that guy's not smart. I don't think he knows what he's talking about. I'm not going to listen to him. Is the jury entitled to do that?
I think they are entitled, if you're talking about a specific expert, sure.
Okay.
But I'm not,
The trial court basis ruling on Dr. Tall's testimony. Was the jury entitled to listen to his testimony and said, you know what, doesn't sound like a very smart doctor to me. I don't want to listen to him. Don't think he knows what he's talking about. Can the jury do that?
no, because in this case, there was no other evidence for them to base a verdict on.
Well, stop right there. So this seems to be exactly what the trial court said. It seemed like he wasn't just focused on the idea that there was no evidence. He seemed to be focused on the idea that there was no expert evidence. What he specifically says is a jury is not free to reject uncontradicted expert findings by multiple doctors. And because Dr. Tall said, yes, the chiropractic care was reasonable and necessary and related to the accident, then that establishes legal cause. So it seems to me that while you might be arguing something different here, and that's fine, it seems to me that the lower court's ruling was entirely anchored on the expert testimony as opposed to anything Mr. Burke said.
Well, I think that the reason, and I see what you're saying there. But I think you also have to realize what the evidence was in this case. There was scores of expert witnesses that came in,
Right.
and Mr. Burke.
Right.
So
yeah,
so-
he was the only.
So that was it. And so when the trial court's saying, well, look, you don't have any expert evidence or expert testimony, that's what was there.
Why is it not appropriate?
Oh, I'm sorry.
Why would it not be appropriate for the jury after listening to Mr. Burke and knowing after listening to all of these experts and all of them are basing their testimony based on the subjective complaints of Mr. Burke, whose testimony they've evaluated, why would it not be within their province to say, you know what, I don't think considering the gap in treatment, the description of the accident, et cetera, that the symptoms that he was relaying to the experts are accurate.
Because the jury can't just say. When evidence is uncontroverted, and that's what we're talking about here. We're talking about whether there was a basis for the jury to say, I don't believe virtually everybody.
Why
In
can't
this
that be the
case,
basis though, I guess?
You know, there is no basis in this evidence that Ryan Berg did not
The
have.
jury can say he went to the hospital, he
Sure.
didn't complain about back pain. Day of the accident, he's there, he's got the doctors, he doesn't say back, doesn't say anything about back. That's evidence.
That is
What happened at the
evidence.
hospital? Okay, that's evidence on the
Yes.
day of the accident, no back pain.
Yes, and there's evidence that Mr. Burke says he had back pain.
All right, but well, hold on, I'm not saying there's not conflicting evidence.
Right.
You're saying there's not conflicting evidence. And what I'm saying is, sure, he went to the hospital, didn't complain about back pain, waited a couple weeks to do anything about it. Couldn't a jury listen to him say that, listen to that doctor and say, you know what? I just don't believe the expert. He's walking around the day of the accident. He didn't say anything about his back. He's had prior back problems. I just think the expert's wrong. And I'm gonna base that on the fact that he's walking around. I see pictures of him carrying 12 packs of or 12 packs of soda or whatever he was carrying. So I just, based on the fact that he's not complaining about it right after the accident, I think the expert's wrong.
And I don't believe that the evidence that the appellant wants you to look at, number one, surveillance is a go-to, whether or not he had muscle. After that, surveillance was done, and it's unrebutted. It was done years and years after. So that has nothing to do with whether he had that pain.
The hospital was that day, counsel. That's
Right.
evidence, is it not? What he says
That's
at the hospital, right? Admissions against interest. Doctor asks him, is your back hurting? Or what are you feeling? He doesn't mention anything about his back. That is evidence, is it not?
It is evidence.
Is it
that-
evidence
of
of
a
how he
record.
was feeling the day of the accident?
It's evidence as to how certainly they put that he felt.
Well,
the day
counsel,
of
it's
the
what he
accident.
said. Is,
But-
was what he said about how he's feeling immediately after the accident, not evidence as to what he was feeling immediately after the accident.
Well, I'm trying to remember the specific record. I think the record said he was sore.
Yeah, here's where I'm focused.
So it doesn't say that I'm denying it. It says that I'm sore.
Here's where I'm focused, and I think it comes down exclusively to some of the stuff that your client said when he was on the stand, because I identify that correctly. He's the only witness. So he didn't seek or receive treatment for his back, soreness or otherwise at the crash site. He didn't seek or receive treatment for his back when he later went to the emergency room for what he believed was a concussion or some neck pain. There were no x-rays or MRIs taken at the emergency room that particular night, at least on his back.
Right.
I have it as 18 days thereafter before he went to go see the chiropractor for what Dr. Tall deemed as reasonable treatment. But if I'm looking at those four facts, and for me, that's where I'm struggling. If I'm looking at those four facts, test isn't whether a reasonable jury would return a verdict. It's whether a reasonable jury could return a verdict. So if I've got those four things, and I otherwise make my prerogative as a trier of fact to believe or disbelieve expert testimony as I see fit, that's my issue with that particular argument on appeal. And I wondered if you could just address that point.
Sure.
Just those four points.
Yes, and my overriding argument is that to be able to use those as a jury, right, to be able to use those, what they have to do is they have to directly be opposite of what the other evidence is, right? So all of the experts are saying that there's an injury. Some of them are saying that there's a disc injury. Dr. Tall saying there's muscle injury. All of them are saying that he had an injury that was caused by this accident. They didn't say it was caused 2 days later. They said it was caused, meaning at the time. So for a jury to be able to kind of latch on to the things that you're talking about, that would have to directly conflict with what the other evidence is. That's what Wald tells us. Wald says, and again, it's a permanency case, but Wald says there's really three ways that you get past a directed verdict on permanency. You get past it by showing there's countervailing expert testimony. There is none in this. You get it by severely impeaching the causation expert. Well, they can't impeach their own person. So that's not there. Or you can present other evidence which creates a direct conflict with evidence. And I would say that those four things I think you mentioned on the days after, they do not create a direct conflict with the fact that he was injured from this crash. That's really what we're talking about here. We're not talking about whether the pain was 10 out of 10, whether it was 5 out of 10, whether he had it. The question that we have is whether he was injured. Right?
Isn't
And
the
so-
second part to your argument, though, that the jury would have to accept the expert testimony? In other words, the jury can reject any portion or the entirety of any expert testimony for your argument to hold.
Well, they're not legally allowed to. When the evidence is in a
When
case,
it's
if I'm
been-
understanding what your question is.
Yeah, I think, so I understand your argument to be essentially that if there's expert testimony saying that there's a cause, that there has to be direct conflicting testimony for a lay witness in order for the jury to take that into account.
Right.
It would seem to me that also there would have to be no basis at which the jury could reject the expert testimony in order for that argument to work. In other words, the jury couldn't have been persuaded by any of the cross-examination that the experts didn't have all the facts, they didn't have the medical record, they didn't have information on pre-existing back injuries, et cetera, et cetera.
No, I would agree with that because that's part of what Walt says. If you what they call severely impeach the witness, right? And there's things that, and there are obviously different witnesses in this case, some plaintiff, Dr. Tall, defense. And so even if you were to say, well, they're a plaintiff expert, there's some cross-examination that goes on, we're just taking all of them out. We still have Dr. Tall. And Dr. Tall, he's a defense witness, he's not under letter of protection. He says very
Aren't
clearly.
these all credibility determinations that you're bringing up now? It's not legal determination. Right,
Um,
what the aspects of Dr. Tall's testimony that the
Right.
jury would take or reject. It seems to me that's all credibility determinations that you're talking about, rather than some like legally binding aspect of Dr. Tall.
It's not I don't believe it's a credibility determination under sort of the believability of witnesses when you don't have evidence to the contrary.
Well, counsel, so it's plaintiff's burden of trial, right? Dr. Tall gets up or your expert gets up, okay? And jury listens to him and said, you know what? I think that expert is just off his rocker. I don't like his credentials. I think his college is a joke. I think he doesn't know what he's talking about. I think everything he said was utterly incredible. You're telling me they can't make that determination and say plaintiff didn't meet their burden? I don't see enough evidence of causation here because they put on testimony from an expert, and I find the expert together. I'm not saying Dr. Paul was
Sure.
the expert in this case. It's just the jury's ability to make the determination. Plaintiff were to establish causation. Jury, here's your expert, or the next expert, whoever. Can they not say, I don't think they better burden. I don't believe the expert. I don't think the expert knew what they were talking about.
I think if you're talking about a specific expert and a credibility determination on that specific expert, I think I would go what you're saying.
Well,
But-
all the
but then-
experts-
But that's when I
These
disagree.
lawyers, every one of these experts, awful. I don't believe what they say. Jury not.
No, they can't. A jury
How does that-
can't.
How does that look, Mr. Lee, in an opinion though? Because there's a whole bunch of opinions out there that basically say that just the fact that testimony is unrebutted, and you see that sometimes in criminal actions as it relates to law enforcement officers with motions to suppress. You see it sometimes in cases involving doctors or medical tests. And it basically says that, and it happens in this context. And the holdings of those cases are consistently, the jury's free to disregard even unrebutted expert testimony, provided that there's lay testimony that says otherwise. So unless we're talking past each other, which might be a possibility, no, but no, and that's fine. But does the opinion that comes out of this case, if we affirm, and I recognize we don't have to write an opinion if we affirm, but if we affirm and wrote an opinion, does that put us in a conflict situation with all of those other cases? And if not, why not?
It does not, because of what you said after the first part. You said a jury is free to reject even unrebutted expert testimony if there is a conflict shown. I'm not sure the word she's used, but if there's lay testimony that
Yeah,
provides
that's
conflict.
that's kind of back to my point.
Right.
I think that you might be putting a lot of stock in Dr. Tall's statements just because it was done under really effective cross-examination. It was a great get by trial counsel. But that doesn't mean a jury can't disregard it just because it came out in cross-examination.
And I'm not, I don't mean to come off as I'm discounting those four. I think that even those four, for this court to say that there was a verdict, I guess, that the jury could give for the defendant, they would have to say that those four, I guess what you said, points were directly in contrast to the evidence that was in front of the jury that Mr. Burke had an injury that was caused by the crash. I don't believe that that does.
Could a jury not say, if my back is hurting, the jury not think, and when they're interpreting the evidence, I don't think a person would be at the hospital with a hurt back and not seek treatment for their back, and they're seeking treatment directly relating to the action of both. Like if a jury made that conclusion, that would put them in conflict with Dr. Charles' testimony, wouldn't it?
It would put him in conflict, but it would also put them in conflict with the evidence. The evidence of the emergency room visit doesn't say that Mr. Burke didn't have a back condition. It doesn't say that he didn't have an injury. We sort of talk about the back because that's kind of what we focused on, but there were other things that were done at the emergency room. There was like CT.
Those things that Dr. Charles' testimony.
Dr. Tall talked about evidence that Dr. Tall talked about treatment that was done up until a certain point and said that that treatment was reasonable and related and necessary to the crash. That treatment includes things like a CT of the head, the things that were done at the emergency room. So he talks about those things that are included within that gap. If I want to say it's 6 to 12 months, I could be wrong with that, but that period of time that Dr. Tall says that workup was related to the crash. It was related to an injury that was from the crash. That includes everything that Judge Straver, you talked about. And so there is no dispute that all of that is related. Mr. Burke didn't say anything in his lay testimony to say that he wasn't related. Mr. Burke even talked about he had low back pain. And so there is no dispute between the records, Mr. Burke's testimony, and every single expert that got up. And so that's why, because there is no dispute, the trial judge was correct in awarding a directed verdict. And I'll say that I wanted to look up the actual part, and Judge Straver, you talked about some of it, but when the trial judge actually granted directed verdict, he said, so there's no possibility that a reasonable jury could look at that and not find that the accident caused some sort of injury to Mr. Burke. There's just absolutely no evidence that would support that. He didn't say expert. He says there's absolutely no evidence that would support that he wasn't injured in some way. So I'm going to grant the motion for directed verdict as to legal cause, meaning that the court finds that the negligence was the legal cause of some injury. The extent of that is up to the jury, but some injury is absolutely undeniable. So that's what the judge ruled. Now, he did, of course, talk about the expert testimony. The parties, when they were arguing, talked about the expert testimony. Appellant's counsel at trial talked about Dr. Foley, who was one of the experts there. But at the end of the day, the court said that there was absolutely no evidence that would support that he was not injured. And there wasn't. So that's why a directed verdict was proper in that case. With my time left, I'll just briefly talk about the jury instructions and jury verdict form and the report, if I can get there. I think the sequence is important here. What happened was obviously the trial court entered a directed verdict and then went to jury instructions. I believe at some point appellant's counsel, or excuse me, plaintiff counsel said, yeah, I think we need to change it. But then the parties actually said, no, I don't think we do need to. And so then the trial judge said, okay, well, I'm gonna tell the jury the instructions are done. And then at that point, they say, well, I think that should have been changed. And so this wasn't a situation where, you know, the defense counsel was just hopping up and down saying, no, we got to change this, judge. We got to say this, this, and this. And the trial judge said, no, we're not doing that. This was a situation where in the middle of the charge by the judge, the parties decided, oh, we have to fix this. The trial judge did what he felt was necessary and actually went, I think, even beyond what a particular directed verdict instruction would be, to tell the jury that, look, all I'm doing is saying there is an injury. The extent of that is up to you. And so any argument that the jury didn't know that going in, I think it's not founded by the evidence.
The odd define, I find causation, I define what. Say I find causation is to some injury without identifying. Causation. Causation requires a thing that is caused. Seems odd in the trial judge thing. I find causation, but it's up to you to find out the term what was caused.
Oh, you're talking about the instruction that he gave, right? It's, yeah, and obviously those are the words the trial judge used.
Can you find causation without finding? Or instruct the jury that causation has happened without telling them what was caused?
I think you can, because of the fact that especially when you have a case where
So
there's,
in this case, what did he tell the jury the cause specifically?
he said that he said that he found that there was an injury caused.
But he didn't identify.
He didn't, and that was up for them to decide what
So he said
what
some-
the
so
what
he
the
said
part of that, the
something
damage.
Got it. Cause, did he not?
He said some injury, he found that some injury was caused by the crash, and the jury was how to listen to to remember what they did, and it has the evidence, and certainly defense counsel told him exactly what he thought was actually caused and talked about that period of time. And so within the context of that,
And if your time is expired.
oh, I'm sorry,
briefly
to
conclude.
the
Thank
context
you.
of that, I think that they were instructed properly. I would ask the court to affirm the trial court order in its entirety. Thank you.
Thank you very much. We have a little over 2 minutes remaining.
Thank you, Judge. I'll be brief. I did want to point out that the defense went through with great detail on directed verdict, all of the lay evidence in the record to support the contention that there was a question of fact, that Dr. Knapp and Dr. Mahan refused to give a definitive opinion on causation, both deferred to the treating physicians. Dr. Banderi, again, who was their primary expert, was seriously impeached, which, as the court knows, is also grounds for the jury rejecting that expert's testimony. And he didn't even know anything about the plaintiff's prior back injury. He didn't know that the plaintiff didn't get any scans at the emergency room. He didn't know that there were no scans at the emergency room, that there was a significant gap in treatment, that he was working out, and that he was, I don't know if he's called a professional, but he also rode crew. All of the doctors also testified that there were pre-existing injuries to the discs in question, that there was some degeneration predating this accident. So this is not a situation where the expert testimony was entirely uncontradicted. It was contradicted both as to the degeneration and also as to the impeachment, which was very effective, and the lay evidence regarding the lack of going to the emergency room. So I think the big picture in this case is there clearly was a question for the jury. The jury should have been given that opportunity, and we would request that the court reverse the judgment in favor of the plaintiff. Thank you.
Thank you. Thank you both for your argument. We're adjourned.